3. What are my company's responsibilities regarding negligent hiring and retention?
Before the recent upswing in negligent hiring and negligent retention lawsuits, companies were generally held liable only for the negligent and intentional acts of their employees committed during the course and scope of employment. However, during the 1990s, the negligent hiring, negligent retention doctrine dictated that injured third parties could sue employers if an employee committed a crime even if the employee was not engaged in the furtherance of the employer's business. In other words, employers may now be generally held liable for the criminal or violent acts of their employees that occur outside the workplace, after working hours, or outside the course and scope of employment. Therefore, it is critical to conduct pre-employment background investigations before extending employment offers to job applicants. In addition, an employer's failure to take appropriate disciplinary measures against existing employees in the form of retraining, reassignment, rescheduling, or termination may likewise subject a company to legal exposure. Hiring candidates without performing reference or background checks is like having a loose cannon on the deck of your ship. Not only do you have a legal duty to select fit and competent employees, but you should also be aware that punitive damages may be awarded if it is determined that you hired or retained an employee with a conscious disregard of the rights or safety of others or because you knew or should have known of the employee's unfitness for the job. Therefore, conduct thorough reference and background checks. Likewise, the best way to combat the negligent retention claims is to conduct timely and thorough investigations of complaints and to reach a reasonable conclusion. Tell me more. The most effective way to combat exposure to a negligent hiring claim is to conduct reference and background checks on all finalist job applicants. Whereas reference checks are business communications between companies regarding applicants' job performance track records, background checks rely on outside agencies to research court records for information related to criminal convictions, DUIs, and the like. It's critical that you document your reference check feedback and place that information in the job requisition folder, not the new hires personnel file. After all, employees have access to their personnel files, and information shared by past employers about their strengths or weaknesses is confidential. This way, should you ever be charged with negligent hiring, you can demonstrate that you acted responsibly in checking with past employers, confirming dates and titles of employment, accounting for gaps in employment, and investigating the applicant's performance history. Background investigation reports may likewise be placed in job requisition folders. However, it is advisable to ask your background investigation company to retain all records related to individual searches. This way, there is less likelihood that the information will be misplaced or inappropriately discovered. Simply stated, there may be highly sensitive information in a background check that you simply don't want any co-workers to have access to. Legal liability also exists when companies fail to investigate or to appropriately discipline or terminate an employee once they learn, actual knowledge, or should have learned, constructive knowledge, of an employee's criminal actions, history of drug or alcohol abuse, or other problems involving an unreasonable risk of harm to others. An employer's failure to take appropriate disciplinary action may be viewed as an authorization or ratification of the employee's conduct after the fact. Negligent hiring and retention claims represent a serious threat to your business operations, especially if you hire individuals whose work activities may affect the health and safety of co-workers and the public, such as employees who deal regularly with customers in their homes or who operate motor vehicles. Such claims may surface any time you hire a new job applicant or learn of harm that results from an employee's negligent or reckless conduct. Treat such instances seriously by exercising reasonable care and taking appropriate remedial action before others are placed at risk.